that okay, we're recording now. So again, welcome everybody, and we're going to have an astounding panel of individuals who will discuss the prosecution of federal agents for violation of state criminal laws and some other issues, because there are concerns throughout the United States regarding ICE agents and allegations of warrantless searches and seizures, non-consensual home raids, stops of citizens based upon their profiles, obstruction of attorney communications with detainees, violations of the Freedom of Information Act, claims that ICE condones federal assaults, batteries, and even homicides under cover of enforcement of federal law. And I'll talk a bit about concerns about the Trump administration's policy of immigration enforcement. So I'll do that before we begin, just about bond and mandatory detention, if I might. The Trump administration has offered expansive legal interpretations regarding bonds and detention provisions in the Immigration and Nationality Act, which would render the majority of non-citizens subject to mandatory detention and ineligible for bond. We have an outline that will be available in our chat room on this with citations, such as the matter of Yasser Ortuda. In the past, immigration judges could generally consider release on bond of each individual or such individuals under the INA if they lack disqualifying criminal records and are not deemed a danger of flight risk. Remember, though, immigration proceedings are civil in nature. Even in criminal cases, most defendants are eligible for bond hearing where danger and flight risk aren't addressed. So taking bond away from most citizens in immigration matters is a drastic measure. As a result, immigration practitioners have been forced to file habeas corpus petitions in federal court, which resulted in circuit court splits. And one can see that regarding the split. It's going to be an issue I think the Supreme Court will have to take up in Washington. For example, the 2nd, 6th, and 11th circuits have rejected the government's position that non-citizens who entered the United States unlawfully and have lived in the country for years or decades are merely applicants for admission, who are necessarily seeking admission, therefore subject to mandatory detention. There are citations in the outline that will be provided for you in the chat room regarding that issue. The 5th and 8th circuits have agreed with the Trump administration's position that it can detain non-citizens who entered unlawfully and were arrested in the United States. The 7th Circuit, meanwhile, is weighed in, but with a fractured opinion, where one judge said the government's interpretation of Section 1225 is wrong. Another declined to weigh in at all, and the third sided with the government. That citation is Castone Nava et al. Versus U.S. Department of Homeland Security, again, in the outline presented with this panel of discussion. So what are the government's goals here? One would say to render large swaths of non-citizens as ineligible for bond by taking away the bond option at a minimum, making it more difficult to obtain bond. And the result is that individuals are forced to have their hearings conducted while they're incarcerated, making it more difficult to retain attorneys, gather evidence, and prepare immigration hearings. These prolonged detentions are a tool to pressure immigrants, it is said, to forego any immigration relief and accept deportation. So that's just one issue that I wanted to bring to your attention in light of the fact that Allah Taher was urgently taken from us today for a family emergency. It will not appear. But we have three of the best with us today, and who will address some of these questions. One question is this: are federal agents immune from state prosecution under the Supremacy Clause? Does the state's attorney have authority and the wherewithal to investigate ICE agents alleged to commit crimes against Illinois citizens? Should a special prosecutor be appointed to investigate and bring charges against ICE agents who commit such crimes? You'll hear something from Mayor Lightfoot about that. I will introduce everybody in a moment. Or is all of this prohibited under the Supremacy Clause of the Constitution? These and other concerns will be discussed by our panel, who I am about to introduce. We have with us eminent counsel Antonio Romanucci. He is a prominent civil rights attorney here in Chicago with a national reputation. He's represented the families of George Floyd, Renee Good in Minnesota, and here in Chicago, Miramar Martinez, who has a pending matter here in Chicago. He will discuss his experiences with excessive force cases by federal agents and unlawful detentions by Border Patrol agents during the Midway Blitz here in Chicago. We also have with us an eminent professor, Alicia Bannon. She's director of the judicial program at the Brennan Center for Justice, which recently published, they recently published her highly regarded article, When Can States Prosecute Federal Agents? This was brought to my attention by Chicago attorney Irv Miller, who is a consultant on the local media here. Professor Bannon will provide an overview of the law pertaining to the prosecution of federal agents and other forms of legal accountability. And finally, but not least, the Honorable Lori Lightfoot, the 56th mayor of Chicago. Mayor Lightfoot previously was a federal prosecutor. She previously had served as chief administrator of the Chicago Police Department on professional standards. She's past president of the Chicago Police Board, and recently she organized the, quote, ICE Accountability Project here in Illinois, which I hope she will discuss with us. After they're done, we'll have a panel discussion, and hopefully if you have any questions to put into the chat room, I'll be happy to address them. With that, we'll begin with Mr. Romanucci.
Thank you, Judge Haddad, and everybody from the American AABAR Association for this opportunity. I'm very grateful to be on this because this is so important for us to be talking about this because this is unprecedented what we're going through. Before I get into the bits of my presentation, it's important to know a little bit about background because it really plays into what we're talking about. I started out as a young lawyer and as a baby lawyer in the Cook County Public Defender's Office, and I spent several years there. I became very familiar with the Fourth Amendment while I was there because I was stationed mostly in what were then called gun and drug courts. They were two separate courtrooms, and I spent quite a bit of time in each, and I became very familiar with the Fourth Amendment as to what reasonable search and seizure, unreasonable search and seizure, when it's lawful and unlawful. And from there, I went into private practice and have been prosecuting police misconduct cases, not only in state court, but federal court all across the country. And Judge Haddad, just so you know, I do not represent Miramar Martinez. Chris Parente does. I do represent Renee Good, and I have represented George Floyd, but I just want to make the record clear. I do not represent Ms. Martinez here in Chicago. She is very good counsel. And so, with that little bit of background, understanding what I know and where my skills have been developed, I do want to go into some of the events that occurred about 14 months ago in our country after this president took office. If we can go to the next slide, please, Ms. Weiss. What happened in about March of 2025 was also unprecedented in our country. That is when this president started signing executive orders kneecapping law firms, attorneys, and higher education. Now, you're saying, what does that have to do with what we're talking about today? Well, it has a lot to do about it because clearly there was a project here that they were following. They were looking at a playbook and they knew that before they were going to have American troops invade American citizens and violate the constitutional rights of American citizens hundreds and hundreds of times per day ad infinitum, that they had to begin by restricting what lawyers and higher education could do, because by eliminating the skills of lawyers and the intelligence of higher education, this administration thought it would have a better chance of success with what it was going to do with this invasion. Clearly, we know that the executive orders against the law firms have been failing. They are currently on appeal. My understanding is that oral arguments have been heard, but there's no decision from the circuits now yet as to that. But we hope that they will end up where they need to be, and that those executive orders should be deemed not only unlawful but unconstitutional. Clients should have the right to hire the lawyers that they wish, and lawyers should have absolute unfettered right to represent the clients that wish to retain them. So, with that little bit of background, we know what started happening just 3 months after these executive orders. The invasion began of not only ICE and CBP into American citizens, into American cities, I should say. And the first city that was invaded, they were the ones on the West Coast. They were Los Angeles and they were Portland. And so we had an idea of what was happening there. But then Operation Midway Blitz occurred starting in about September of 2025. We knew that agents were going to come in, but we certainly didn't know with what force and effect that they planned on coming into Chicago. And when they did, I think I certainly was caught by surprise at how violent and forceful and without any due regard to the First Amendment, the Fourth Amendment, or the 14th Amendment that these agents came in trying to enforce the mission. And what was the mission? Well, the mission was the worst of the worst. That was, we were going to get the worst of the worst. And indeed, what wound up happening that we saw, if we can go to the next slide, please. What we saw, what was happening really, was that they were violating the rights of American citizens consistently and continuously. Now, this picture is of Lee Kunkel. She's a journalist. We represent many, many people from Operation Midway Blitz. And folks, who is it that we represent? We represent journalists. We represent village trustees. We represent attorneys. We represent citizens, all American citizens who were exercising their rights under our U.S. Constitution. The Bill of Rights is not something that is optional. It is mandatory. We have the right to assemble and freedom of speech. And what was happening is that they were just getting literally mowed down with either pepper balls, with batons, with tear gas. And so what was happening is that the clients that we currently represent, the ones who were exercising their rights, were being detained in furtherance of this false mission, this narrative of the worst of the worst. These narratives are extremely important because even going back to my days as a public defender, I learned that law enforcement loved narratives because if you can pretextually have a narrative, and the narrative that applies here, especially to the injuries and the death cases that have occurred not only in Midway Blitz, but also in Minneapolis, there's always that particular language that said that the law enforcement officer was in imminent fear of his life or that of others and that he felt threatened, right? Or she. That is always the pretextual language that you have that follows any use of force because that is what the law says lawfully allows a law enforcement officer to use force. If they weren't in fear or if they weren't in fear of harm or bodily injury or death, then the use of force, deadly force, is not allowed. It's unlawful. So that is the pretextual language that we saw coming out of the administration, right? Kristi Noem, Stephen Miller, Tom Homan, all of them use these false narratives in order to justify the end. So those narratives, this common design, as I really like to refer it to, this common design of false narratives preceded all of these wrongful uses of force. And what was happening? So during Operation Midway Blitz, constitutional rights were being violated hundreds and hundreds of times per day. And I know that it's going to be referenced later, so I'm not going to really talk about it except reference the fact that there have been zero, no prosecutions of any law enforcement officers stemming from any of the acts of federal law enforcement officers in Operation Midway Blitz. And I know that Mayor Lightfoot will address that issue. So what what we also saw was happening is that not only were American citizens being detained, they weren't being detained with any due process. They were being detained without hearings. They were being detained and then they were being basically stolen and kidnapped from wherever they were protesting, peacefully protesting, taken to facilities, op operation facilities off of where they were protesting. And then when they were released, they were being taken to locations where they weren't, that they didn't even know where they were. They were literally being driven in white vans, the doors open, and basically pushed out and told to find their way home. This is something that's been unprecedented in our country. We have never seen this invasion of American citizens in American citizens, cities by American troops and had this vast and wide violation of constitutional rights. So that's a little bit of the background in Operation Midway Blitz. And that was just the warm up then for the next slide, which occurred in Minneapolis. And that was Operation Metro Surge, which happened there. Now, I have the very strong suspicion that once they finished their mission or didn't finish their mission here in Chicago in Operation Midway Blitz, they felt that they could go into Minneapolis in the beginning of December because it gets a lot colder there a lot sooner, and that they could continue their mission in a very colder environment and have had a lot more success than it did in Chicago because we stood up to them. But they didn't know what they were getting from people in Minneapolis. They had no idea. Um, I strongly believe, and I urge this tremendously to another group that I spoke to when I was in North Dakota, that they should be so grateful to their neighbors to the east because Minneapolis stood up to this surge, and not only did they stand up to it, folks, they stopped it. I mean, we were told that they were going to come back in and surge us again in March. When they left us in November, we were told that they were coming back in March. And what Minneapolis did was certainly um, um, change the dynamic of what happened here. Kristi Noem was terminated. Tom Homan had to come in. Lewandowski is out, who was the brains behind what Kristi Noem's was doing, and I use the word brains loosely because those are cockamamie brains. So Minneapolis really changed the dynamic. If we could have the next slide, please. And so I'm going to be very sensitive to our time. I have about 5 minutes, so I'm going to run through these next slides and give you an overview of what happened here, because clearly what happened is once again we had two individuals in a vehicle who had just dropped off their child from school. Renee Good and her partner Rebecca were in a car, and as they left their child from their school, they got caught in between blocks where there was another surge happening, so they stopped to watch. And what happened when they stopped to watch? More cars came loaded with federal agents, and when those vehicles came, Rebecca got outside of her vehicle and started questioning why they were being stopped. And that is when Jonathan Ross approached Renee's vehicle, and she told him that I'm not mad at you because there were vehicles that were surrounding her. She literally said, I'm not mad at you. But what happened? Jonathan Ross walked in front of her vehicle as she had her wheels pointed to the right, moving away from him, and he took a first shot at her. And that first shot entered the right lower front windshield of the car. And then he moved to the side as the car was still slowly moving away from her. He lined up 90 degrees at her front door, aimed at the window, and took two more shots. Now, those two shots are very, very important, and I'm going to explain why. And he wound up killing her. He executed her right there on the street because then her car lost control. It rode down the street. It crashed into another vehicle, and shortly after she died. Can we have the next slide, please? And so right away, we knew that once the Good family contacted us and we started evaluating the case, we were going to face a lot of challenges, right? This is not a case where we were going to be suing or looking into a claim or investigating the Chicago Police Department, the Minneapolis Police Department, or a local sheriff. This is the federal government. This was clearly federal law enforcement officers, and let's just get this out right now. The same rules do not apply to federal law enforcement officers as they do with state law enforcement officers. We do not have the right to sue a state officer, I'm sorry, a federal officer, the same way that we do a state actor. We don't have the right to sue any of the governmental agencies until we file a Federal Tort Claim Act. Only then, after it's denied or there's no response from the federal government, may we sue. And then once we do sue, we cannot sue the officer within that particular complaint. That is a separate complaint known as a Bivens case, and Bivens has been seriously undermined by our United States Supreme Court because of its key context ruling, referring back to the FTCA and the ability to sue governmental agencies. And we have to remember that one of the rights that we would have that is, you would think is inherent, the Seventh Amendment, which is the right to a civil jury trial, that has been taken away by our government. And we cannot have a civil jury trial under a federal law enforcement officer case such as this one. We only have the right to have a judge hear the case. So we had a lot of uphill battles that not only did we have to explain to the family, but that we have on our own. So can I have the next slide, please? And so what we did, what we knew what was happening, not only in Los Angeles and in Chicago and in Minneapolis during these surges, what we knew is that the public was crying out for transparency. They wanted to know truth. They wanted to know why. They wanted to understand why this was happening. So we undertook a strategy of coming out forthright and telling the public that we will be transparent with you because our government will not and won't be transparent with you. So we will. We'll give you as much truth as we can as we know it. So we undertook a very strategic strategy with the Renee Good case, obviously with the client's consent, to start sharing any letters that we were communicating with the federal government. Uh, Todd Blanche, who was Deputy Attorney General at the time, who we were writing letters to this day, you all know how many times he's responded to any one of our letters. Zero. But in the meantime, he's trying to prosecute cases from 30 years ago because it fits the president's agenda. So we have had zero response from the federal government to any of our communications, either requests for preservation of evidence, requests for any information for inspection of the vehicle, absolutely nothing. Cell phone data, we don't have anything. But what we
Tony,
were,
before you wind up, I want to make sure that later on you can discuss some of the tools we have here in Illinois to hold federal agents accountable here.
of
I,
course,
I do want to get to the other panelists, but please continue.
I'll wrap up in a minute.
Okay.
Um, so what we did was we did have the ability to have Renee Good's body available to us, her remains. So we had the independent autopsy done, and we released those results. And that result is the one where we allowed the American people to make their own decision. It's what we do as lawyers very often is we give facts and we let jurors come to us knowing what the answer is. And when we released the findings that she was shot basically at a 90-degree angle, where the bullet wound entered the above her left ear and exited outside on the right side of her head, basically by the right ear, we let people make their own conclusion that she was shot while the car was moving away from her, where this officer was not in fear of his life or of serious bodily harm. So that is my presentation on not only Operation Midway Blitz here in Chicago, but Metro Surge in Minneapolis. And maybe if there's time, I'll save some of my last couple of slides for later. So thank you very much, Judge Haddad, for this opportunity.
Thank you for your courage in following through on these matters. Now we'll hear from Professor Bannon. Proceed. You're going to allow her to unmute.
There we go. Um, Thank you so much for the opportunity to participate in this important conversation. As Judd Haddad said, I direct the judiciary program at the Brennan Center for Justice and also edit our publication called State Court Report that looks at state courts as well as the role of state constitutions and other state laws in our systems of checks and balances. And I guess what I would do to kind of tee up my remarks is to kind of emphasize the role of states in that system of checks and balances. I think often when we talk about our constitutional system, we look at the three branches of our federal government, but federalism and states are very much baked into our constitutional system. And I think right now we're increasingly seeing the importance and role that states and various state actors play as mechanisms of accountability, including in the context of executive actions and some of the abuses that we've seen coming from ICE. Next slide, please. So I'm going to focus most of my remarks on a specific issue, which is the role that state laws and state prosecutions can play as a mechanism of accountability for federal actors. And this, people may remember in earlier this year, around the time of the surge in Minneapolis, you had prominent leaders, including Vice President Vance, make statements that federal officers are absolutely immune, that state law has no role to play in limiting abuses by federal officers. And those statements prompted me to write this piece that Judge Haddad mentioned and that I believe is included in your materials, looking at the law around that, which I think is crystal clear that it is absolutely not the case that federal officers are absolutely immune from state prosecutions. That being said, there are limits and a whole kind of set of case law about when and how those prosecutions can take place. So I'm going to spend a little bit of time just walking through what the legal framework is, as well as what some of the kind of more practical challenges and hurdles can be to state prosecutions, because certainly it's not easy to do. There are certainly challenges associated with it. At a high level, the overall kind of legal framework that governs state prosecutions of federal agents comes from an 1890 U.S. Supreme Court case called In re Nagel. And this is a case, it's sort of interesting fact pattern. Essentially, you had a U.S. Marshal in California who was protecting a Supreme Court Justice, Stephen Field, who was on a train and then attacked by, oddly enough, a former judge, a former Chief Justice of the California Supreme Court, who had a big grudge against him and who had threatened his life previously. He attacked the Supreme Court Justice, and the Marshal, in the course of protecting the Justice, killed the assailant. And then state criminal charges were brought against that Marshal. And what the U.S. Supreme Court ruled in re Nagel was that in that instance, that state prosecution could not go forward because the Marshal had been proceeding under their duties as a marshal, and their behavior was necessary and proper to fulfilling their duties. And this principle became known as supremacy clause immunity. And the basic framework, I mean, it makes sense if you think about it. You can't allow criminal prosecutions that would undercut federal officers' ability to do their jobs, to do their duties. And so that's rooted in the supremacy clause. Federal law is supreme. So if federal officers are doing their duties and acting reasonably, then they're immune from state prosecution. And as lower courts have interpreted and applied Nagel, there's a basic test that's been developed about when prosecutions can go forward. So the first question was the officer's actions fully outside their official duties? So were they not actually acting as an officer, even if they happen to be an officer, were their actions kind of fully outside of their official duties? In those cases, a prosecution can go forward. The other instance is if the officer was performing their duties, but their conduct was unreasonable or unlawful. And so in those instances, if an officer's they're acting as an officer, but they're not behaving reasonably, that too can be a basis for state prosecution. Next slide, please. So I'm going to walk through a few cases that give a little bit more of a sense of the contours of how this doctrine has developed over time. There's a fairly prominent case from the early 2000s, Idaho v. Horiuchi, which related to an effort by an Idaho prosecutor. Oh, back one slide, please. An Idaho prosecutor who was seeking to prosecute an FBI sniper who had killed an unarmed woman as part of the infamous Ruby Ridge standoff. And here, in this instance, the Ninth Circuit ruled that supremacy clause immunity did not apply and that prosecution could, in fact, go forward. And to be clear, this was at an early kind of motion to dismiss phase. So essentially what the court found was that there was a dispute of fact. There was enough evidence in the record to suggest that the FBI sniper's behavior might not have been reasonable, and that dispute of fact was sufficient at this phase of the prosecution to defeat supremacy clause immunity. Now, I'll note that this case, and I'll get into more later on because it also highlights some of the challenges with state prosecutions. Ultimately, this case didn't move forward. A new prosecutor took office. The prosecutor that had brought those charges left office, and the charges were dropped. And so then the case was later found to be moot because the charges had been dropped. But yet, I think the opinion still lays out some of those the basic framework of how supremacy clause immunity operates. The next case I'll highlight is an older case, but I think goes at some of the reasons why you might want supremacy clause immunity in the first place. So this was a case in which a the Northern District of Mississippi did find that supremacy clause immunity applied to a state prosecution. This was a prosecution brought by state officials against a federal marshal who was tasked with protecting James Meredith and others who were seeking to integrate the University of Mississippi. And essentially a riot ensued. There was violence going on as students were trying to access the school, and tear gas was used by the federal marshal as part of controlling the crowd. The state sought to bring prosecutions, and this prosecution was blocked under supremacy clause immunity, saying that the marshal was acting reasonably within the scope of their duties in protecting Mr. Meredith. So this is an example in the other direction of a state prosecution being blocked. Going back a little older, and I will say that if you look at the pace of cases, there are a lot more in kind of the early 20th century than we see more recently. Now, there are some that I think people don't even necessarily register as supremacy clause immunity today. So, for example, there are plenty of cases of a postal worker who drove recklessly and gets prosecuted by a state. I think people don't even necessarily think of those as supremacy clause immunity cases. In a sense, I mean, they raise that issue, but courts have consistently allowed those sorts of prosecutions to move forward, often not even considering a question of supremacy clause immunity. But in terms of cases that are a little more factually aligned with some of the dynamics we have seen in Chicago, Minnesota, and elsewhere, there's a lot more precedent if you go kind of to the early 20th century. In the Prohibition era, there were a number of lower court cases where states did successfully charge federal officers for using lethal force in carrying out arrests and seizures related to the enforcement of prohibition. There are a couple cases, including which included with some echoes to the Renee Good case of guns being discharged at moving vehicles. And there are instances there where courts allowed those prosecutions to move forward, finding that supremacy clause immunity was defeated. There's also a 1906 U.S. Supreme Court case in which the Supreme Court allowed Pennsylvania to go ahead with a prosecution. And get in an early stage, there were disputed facts with soldiers who were charged with killing a civilian who had been accused of stealing from a federal arsenal. And there were claims, witnesses said that the person had already been captured, was under the control of the soldiers when the soldiers shot him. And there the Supreme Court said, quote, "It could not reasonably be claimed that the fatal shot was fired in the performance of a duty imposed by federal law if in fact the person was already under the control of the soldiers." So again, that's an instance where the Supreme Court allowed a state prosecution to move forward and found that supremacy clause immunity did not apply, at least at that stage of the litigation, based on the disputed facts. Next slide, please. So just a few more considerations to kind of understand the contours and some of the challenges when it comes to state prosecutions of federal agents. One dynamic of the law that's important to understand is that under U.S. law, the removal statute does allow state prosecutions to be removed to federal court, if there are these claims of supremacy clause immunity being raised, so that a federal judge will be the person to assess those claims of supremacy clause immunity. Importantly, the prosecutor will continue to be the state prosecutor. So it's not that the personnel charging the case would change, but in terms of the judge and the jury, et cetera, that would all be happening in federal court, or at least the defendant would have the option to remove it to federal court. Another important consideration when it comes to state prosecutions is ultimately a conviction is a state conviction. It's not a federal conviction, so it's not subject to the president's pardon power. Another important component when you're thinking about tools of accountability in the current moment. Concerns or challenges when it comes to when it comes to these kinds of prosecutions. One is that there can be very serious evidentiary challenges, particularly as we're seeing now. If you have the federal government, which may very well have access to a lot of evidence, not willing to share evidence, cooperate in ways that it traditionally has with state investigations. There's actually ongoing litigation in Minnesota right now in federal court, where the state or prosecutors in the state are seeking access to evidence. The primary claim is rooted in the Administrative Procedure Act, essentially saying that the federal government is not following existing procedures about when to provide evidence when requested as part of a state investigation. Another question is, or another potential issue is around extradition. How do you actually kind of access people when they're being charged? And so that's another potential challenge if a person is based in a state that is not willing to extradite. And then there's also a lot of law that still kind of remains to be defined. The last Supremacy Clause immunity case to reach the Supreme Court was in 1920. And there's a lot of differences within the circuits around exactly the contours of how this law applies. What are the standards for determining, for example, what's reasonable? And so those are the kinds of things that I expect as we see. And I should note there have actually been now 2 state prosecutions brought very early stages in Minnesota, in Hennepin County, in connection with these ICE surges. And so we're going to see, I think, this law get tested and likely move up to I would not be surprised if some of these issues land in the Supreme Court to resolve in the last instance. But again, I think that the principle that the absolute immunity does not apply, I think is quite well established, and I would not expect to be upended.
Okay,
Next slide.
Professor, I don't mean to interrupt you, but we're going to move it on, but I do want to ask you at the end about what tools we have here, and what tools do we have
Absolutely.
to prosecute these cases. I'm sorry to interrupt you.
No, please.
But if I don't, Mayor Lightfoot will hold me in contempt of court. I don't know if she still has the power. Mayor
Judge,
Lightfoot?
before you introduce Mayor Lightfoot, if I could just make an announcement to everybody, could you please submit your ARDC numbers to info@aabar.org? We put it in the chat to make sure that we can submit your attendance for CLE credit. Thank you so much.
info@aabar.org. Okay. Mayor Lightfoot, you're on.
All right. Thank you, Judge.
Thank you very much, Professor Bannon. Thank you very much.
And in the interest of time, I do have a deck, but I'm going to try to go through it as quickly as possible and see if we can get this done in under 7 minutes, so we have plenty of time for closing remarks. Marvet, if you would be so kind to pull up my deck. Or if it's Joe, I'm not sure. Here we go. And you can stay on that page for the present. So I just want to frame my personal opinion about these issues. As some of you know, I had the privilege of being the 56th mayor of this city. My first summer as mayor in 2019, I was down on the southwest side. I was asked to go and visit with some young people, preteens mostly, who were involved in After School Matters project, where they were painting a mural on the side of an abandoned building to beautify their community. So I met with these young people and was admiring the work that they were doing. They were in a very early stages of sketching out what they wanted to do. But it felt like something was wrong. And I came to learn in conversation, gently coaxed out of them, that these young girls, who were at that time the age of my daughter, were worried that they would go home that day or another day and find an empty house. Because 2019 was another time like this, where President Trump in his first term was rattling the immigration saber and demonizing all people who he deemed to be the other. And these young girls, who most of whom were the first primary English speakers in their households, understood exactly what the moment was, and we're living in fear. I think about that moment a lot. And I certainly have since the so-called Operation Blitz started last fall. And it fuels me to know that even as an African American, where I have no fear of being deported, I know that if my brother or sister has that fear, I have to stand up and act. And that is what led me to start what's called a reporticenow.com. Our primary mission is to be a centralized repository of all the evidence that's out there about the misconduct and misdeeds of federal immigration agents writ large. We use ICE for shorthand, but we really mean DHS, ICE, CBP, and all of the other federal actors who have been part of the militarization of government law enforcement against residents in LA, in Chicago, and in Minnesota, and other cities across the country. We can go to the next slide. I'm going to give you a little bit of context for how we got to where we were. President Trump, when he was campaigning in 2024 in Iowa, said and talked about something called the Eisenhower model. Well, if you do any study or if you're a student of history, what the Eisenhower model was a plan called Operation Wetback, which was intended to be at that time the largest deportation effort in the country's history, so that Trump was reaching back to another dark moment in our history as impetus and incentive for what he planned to do. And Stephen Miller, who many of you know, is the primary architect and executor of this plan, says, quote, "Any activists who doubt President Trump's resolve in the slightest are making a drastic error. Trump will unleash the vast arsenal of federal powers to implement the most spectacular migration crackdown." And unfortunately, that's precisely what we have seen. Next slide. To compare and contrast CBP and ICE, and why I think this is important, I'll explain in a moment, but pre-January 2025, CBP numbers were modest, and most of those resources were at the border, and the annual budget was $33 billion. It ballooned as part of the One Big Beautiful Bill to over $170 billion. Think about the contrast and the expansion of resources devoted to CBP and ICE. Next slide. The problems with mass deportation for this administration. The reality is, as we all know, most immigrants living in our country are peaceful and law-abiding. Their participation in local economies, from restaurants, hospitality, other kinds of businesses, is essential. And federal immigration agents are few in number. Why they are so frustrated by sanctuary cities or sanctuary states like Chicago and Illinois, because they cannot do what needs to be done with the limited number of resources of federal immigration agents alone. They have to have the partnership of local law enforcement in order to carry out their mission. And anything that stands in that way is viewed not only as a problem, but viewed as the enemy. And the local sanctuary city restrictions are exactly the embodiment of that enemy for these forces. Next slide. How did we get here? CBP's used in urban settings, and I'll whip by these fairly quickly. On the right, the infamous Greg Bovino, who clearly fancied himself as a Nazi officer in the manner of his dress, but importantly, in the manner of the execution of the directives that he gave to CBP agents who were brought to Los Angeles, then to Chicagoland, and then to Minnesota, with disastrous results everywhere. Next slide, please. This is Los Angeles. As you can see, what happened in Los Angeles is different than Chicagoland or in Minneapolis. The local state National Guard was mobilized against the people, and it became an incredible flashpoint. Luckily, through the ambitions of local attorneys here and the courts here, we were able to stop this militarization of federal immigration actions in Chicago. Next slide, please. I want to pause on this for a moment because there are a couple of important points. Mr. Gonzalez was killed on September 12th, 2025 in a botched car stop. Car stops are one of the most dangerous and difficult operations for any law enforcement. He had just dropped off his 2 sons. He is a widower. He just dropped his 2 sons off at school. 2 individuals who are dressed, as you see in this photo, came up to his car. He probably thought he was getting carjacked. And he did, frankly, what any of us probably would have done. He panicked and he tried to drive off. And then what happened? They the back of his car in a moving vehicle. If you can see in the bottom right-hand corner, that is his car that ended up crashing into a parked truck. There are no shattering of the front windshield. It's all on the side and the back, a la Renee Good, which tells you that he was driving away. He was not a threat to anyone. You should know that police departments across the country, and it is now standard best practices, have outlawed shooting into moving vehicles since the late 90s and early 2000s. And yet, Mr. Gonzalez was killed in a botched traffic stop where the agent shot at him as he was leaving in the village of Franklin Park. And I will come back to that point in a moment. Next slide. Next slide, please. Miss Miramar Martinez shot 5 times by an ICE agent who bragged to his buddies in text messages that he had 5 shots, 7 holes, and the body camera tells us that they were bragging and waiting to do harm to Miss Martinez, that they initiated the traffic accident. They rammed her car and then jumped out and ended up shooting her. She was charged federally. The attorney's office here, the arm of the Department of Justice in Chicago, with obstructing the actions of these ICE agents. Those charges were later dismissed with prejudice, and I hope Mr. Parente does sue, because she also deserves justice. Next slide, please. How did we get here? And I don't want to steal Mr. Romanucci's thunder, but I do want to highlight a couple of points. We have all seen the horrific videos of Miss Good saying, "I'm not mad at you, bro." She is driving off. But what's important in thinking about that video, and what jumped out at me, is it reminded me of the video of the killing of Laquan McDonald by Jason Van Dyke. And why I say that is this. All of the other agents were standing around. They were not in confrontation with Miss Good and her wife, and neither were they with the agents. The last agent in comes out of his car with his gun drawn and immediately flees to the car, tries to drag her out. When she drives off, then he shoots. If you go back and you compare the video of Laquan McDonald and Jason Van Dyke, it's the same exact scenario. Everyone is giving McDonald time and distance as they were trained. They are not engaging with him. But Jason Van Dyke, last car in, comes out of his car, gun drawn, 16 shots, and Laquan McDonald is dead. The similarities are overwhelming to me when I think about this poor woman who lost her life because an agent was poorly trained, poorly supervised, and who had no justification from any angle to fire his weapon that day. Next slide. Similarly with Mr. Preddy, by the time the agent shot him, they had taken his weapon. He was on the ground. He was being held. The bottom right-hand picture shows they shot him when he was on the ground, not resisting arrest, and he was unarmed. Next slide. And what do we know about what's been happening with these agents? Well, we have this whistleblower who testified before Congress earlier this year. Next slide. And what Mr. Swank told us was that they have cut the hours of vital classes by 240 hours from 584, and that the lessons that they cut were teaching the Constitution, our legal system, firearms training, use of force, lawful arrest, proper detention, all the kind of things that you need to know if you are on the street as a federal agent operating with the force of law, where you have the ability under the law to engage in force if necessary. Next slide. And Gil Kurlikowski, who was the Obama administration's Customs and Border Protection head, said, and I quote, "Most Border Patrol agents did not have the experience in policing an urban environment," end quote. This is so true. Next slide, please. When you look at what I see as somebody who has spent years involved in local law enforcement accountability, they're poorly trained, unsupervised, they had arrest quotas, and they are let loose in an urban environment for which they are totally unprepared. They have met peaceful protests with lethal force, escalating instead of de-escalating, repeated routine violations of First, Fourth Amendment rights and due process rights. Let's next slide. The result? 3 people murdered, multiple people shot and murdered, countless First Amendment violations, countless Fourth Amendment violations through arrests and seizures in court buildings, schools, businesses, and homes, and cars, countless numbers of excessive force violations, and a total erosion of trust in government at all levels. Fear and chaos among immigrant populations, economic harm to businesses that depend upon immigrant labor, and higher prices to consumers. Next slide, please.
Before you finish, Mayor, I want to lead you and the panel into a question, which is this. When I was a prosecutor, we had a Republican state's attorney, Bernard Carey, who initiated a felony review unit that would investigate any police shooting. We would go out and we would interview the witnesses and present the evidence to the state's attorney to make a decision whether it was justified. What tools do we have today for these? We heard from the ground situation, from the fact ground situation from Mr. Romanucci. We heard the law from Professor Bannon. What are the politics involved here that would allow us to proceed with a prosecution here in Illinois?
Well, that's where I was planning to end.
There you go.
We all know the old expression, where there's a will, there's a way. And the problem here in Cook County is there's no will. The state's attorney, the sheriff, Chicago Police Department, state police, all could act if they chose to. And I mentioned Mr. Gonzalez was shot in Franklin Park. That is a police force of 46 people. And by their website description, no investigative resources whatsoever. Same with Broadview. So many violations of civil rights in Broadview. They have a police department of under 25 and no detective or investigative resources. They depend upon the state's attorney, the sheriff, the state police, regional law enforcement bodies to be able to come in and assist them when there is something of the magnitude of a homicide or a serious shooting or excessive force. The fact that our local law enforcement has not risen to the moment is a disgrace. The tools are there. And Judge Haddad, you mentioned felony review. It's more than that. Recently, the state's attorney announced a collaboration among various levels of law enforcement to attack public safety issues on the CTA. Bravo. But where's the same energy and urgency when it comes to these excesses of federal immigration agents. It's hard, as Professor Bannon has outlined, as Attorney Romanucci has outlined, but it is not impossible. If you do not start, it will never start. It will never finish. The evidence is there. There's so much videotape evidence that's out there. That is a part of the reason we formed reporticenow.com. The ICE Accountability Project was to not only be a repository to gather all this information about specific incidents, but frankly, to take away the excuse of local law enforcement from stepping up and doing its job.
Maybe somebody else wants to chime in on this. We hear the facts on the ground from Mr. Romanucci and the mayor. We know of the law. What are the politics involved that may or may not have something to do with whether anybody moves forward with regard to a prosecution? Mayor Lightfoot, there was a special grand jury or say special prosecutor that was advocated by certain groups. What happened to that?
So just before we went on the air, Judge, we saw the breaking news account that the chief judge, the presiding judge of the criminal division, denied the petition for a special prosecutor. There were a number of civil rights organizations and individuals of prominence that brought this petition, and unfortunately, it was ruled down today. But that just gives the state's attorney even more cover, frankly, not to do her job. But I don't want to just pick on the state's attorney, as I said. The sheriff needs to be held accountable. CPD needs to be held accountable, as does the state police. There's a lot of overheated rhetoric by politicians. That rhetoric is not matched by actions.
Anybody else wish to chime in on that?
I would like to chime in because what the lack of a prosecution or even an investigation does, especially in these circumstances, it does limit avenues of accountability. Obviously, I am interested in civil accountability, but we also want to make sure that all avenues of accountability are administered, whether it's criminal, whether it's legislative, whether it's the civil side. But also when there's no criminal investigation, and now we have the federal government who's put a brick on any level of us investigating the case, they won't share information. We're up against a wall. It's a very challenging, difficult situation. We've had to file a Section 41 petition against our government so that we can get access to the evidence in Renee Good's case because they are denying us any accessibility to any of the evidence. So without anybody else pursuing accountability, it's hard for anybody to get accountability. And what happens when there's no accountability? Jonathan Ross keeps on working. The officers who commit the violations keep working. And these commissions, they keep happening. Or what happens is there's impunity.
Professor Bannon, you have anything to say on that?
Well, I'll just say very briefly on other mechanisms of accountability that there are now 5 states, including Illinois, that have passed laws providing for civil remedies against federal officials for constitutional violations. It remains to be seen. There will be litigation around the enforceability of those, but I think it's an important and notable trend of creating different state avenues, using state law to hold federal officers accountable.
And that's part of the immigration bill that was signed earlier this year by Governor Pritzker.
Exactly.
Yeah.
So the idea of a special grand jury or a special prosecutor is possible, but nobody has picked up the mantle on this. Are there politics involved at all? Mayor Lightfoot, look, we heard the facts on the ground from Mr. Romanucci and the law from Professor Bannon. What about the politics involved, Mayor?
Well, look, I'm a failed ex-politician, so I hesitate to jump in, but here's what I will say. It's easy to rattle the saber and to play to the crowd. It's much more difficult to show leadership and actually accomplish something. The Miss Miramar shooting took place in Chicago, and police officers were frankly injured by the actions of the federal immigration agents. One would think there would be an incentive to do something. And yet we've seen no movement whatsoever within the confines of the city of Chicago. Franklin Park is a very small community, very small police force. I can only think that the powers that be in our local law enforcement actually don't want to go up against the federal government out of fear. But fear, if you're afraid, you're in the wrong job. If you're a prosecutor, if you're a sheriff, if you're a superintendent, get out. Do something else. This is a time for people to step up and be bold and use the power of their office appropriately to at least conduct investigations. As my friend Tony Romanucci says, the absence of any kind of investigation by going out to the crime scene and collecting the evidence appropriately really hampers any other avenue of accountability.
In felony review, that's what we had to do. We interviewed all the witnesses. If there was a police shooting, we submitted affidavits and statements, and they were submitted to the state's attorney for consideration. Under a Republican administration, and it followed a Democratic administration with, if you remember, prior state's attorney Hanrahan and the Black Panther raid that ended in the killing of Fred Hampton. And that's when the state's attorney, the new state's attorney, implemented investigative tools to hold law enforcement accountable. I don't know what the situation is now in that office or
Judge,
anywhere else.
It's even more enhanced. If I can, just a couple minutes here. Number one, there is still felony review. As we speak, there are assistant state's attorneys that are assigned on a 24-hour basis to respond, to direct, and assist law enforcement in putting together cases that exceed the probable cause standard. I led the Office of Professional Responsibility back in the early 2000s. We had a written agreement with the state's attorney then. I'm told that it still exists, that any instances where there's a suggestion of a killing, a shooting that was gone awry with the Chicago Police Department, the state's attorney comes in and conducts its own investigation. It has over 100 trained investigators, many of them former police, former sheriff's deputies, that do their own investigations as we speak. The tools are there.
Okay, thank you. Jawad, Mr. President Shalaby, do we have any more chat room questions? Do we have time for any more?
We actually do not, Judge.
Okay, then I think I'm going to close this off and thank everybody for the information provided. I also want to thank our committee, Marvette Swice and Joe Holmesy, for the work they did. Please submit your ARDC numbers to AABAR. What is it? What is it? I'm sorry, Joanne, what is it?
It's info@aabar.org.
.org.
Put it
Okay.
inside the chat.
All right. All right. With that, I wish to thank the panelists for their wonderful presentations and wish and bid everybody goodbye. Remember, this is an ongoing CLE series, the only of its kind in Illinois that deals with diversity and inclusion. Every twice a year or every year we present these CLEs, and we've had a long history of doing it for 6 years now, and we will continue to do it regardless of any DEI issues that abound us these days. So I wish you all very good day, and thank you for your participation and attendance.
Thank you.
Thank you.
Thank you, everyone.